The responsibility of maintaining a fair and equal justice system rests upon your shoulders. Allowing the reappointment of Judge Lee Harris for another term would show the citizens of Virginia that white nationalism in the Virginia courts is tolerated and approved by the Senate and House of Delegates.
You can respond. You don't have to respond.
The only thing I would say is Mr. Spanos is not before the court.
Well, thank you for being here this afternoon. Appreciate your service very much.
Thank you.
Thank you.
The thing I would say is Mr. Spanos is not before the court.
Well,
the thing I would say is Mr. Spanos is not before the court.
Well,
Judge Harris stood before you shamelessly and knowingly made false statements to the Joint Judicial Subcommittee. Judge Harris could only state 8 words in his defense, despite having the same 26-page letter that I sent to you on December 4, 2021. Mr. Spanos has not appeared before this court. Judge Harris recognized that I had turned myself into the FBI officials in Athens, Greece in 2018 as to be voluntarily extradited to Henrico. Yet Commonwealth Attorney Shannon Taylor refused to transport me. Judge Harris recognized that I could not transport myself as I had a federal UFAP and Interpol red warrants on me. Only with a U.S. Marshal escort and Henrico Circuit Court documentation could I board a commercial flight to travel to the United States. Judge Harris has done everything in his power to make sure I do not appear before his court. As on December 4th, 2018, Judge Harris and Deputy Commonwealth Attorney Michael Feimel had ex parte meetings to deny my motion to be transported to Virginia. Deputy Commonwealth Attorney Michael Feimel printed off the email service copy without the second and signature page to my motion for transport and had Judge Harris issue an order denying my motion for transport without the second and signature page to my motion. Deputy Commonwealth Attorney Feimel then filed the partial motion for transport, and Judge Harris' order before my original wet copy had been filed with the Henrico County Circuit Court. The original wet copy has yet to be filed in the Henrico County Circuit Court's office. On January 2, 2019, Judge Harris issued a second order denying the motion for transportation, stating there is no basis to grant motions. Judge Harris, with a simple signature, could have brought me before his court and be prosecuted for 13 indictments alleging I was the hub of a 600-kilo cocaine organization. Yet he was protecting the 30 to 40 white affluent professionals from being prosecuted. Let's review Judge Harris's participation, support, and protection of his white nationalist friends. On May 10, 2021, Judge Harris issued an order denying a motion to disqualify the Henrico Commonwealth Attorney's Office from my case for conflict of interest. He ordered that all motions are denied as the defendant has never been served with any indictments to submit him to the jurisdiction of the court. On May 19, 2021, 9 days later in his defense pleadings to the Louisa Circuit Court, Judge Harris states 3 times, Spanos was served with the 13 indictments in the capias in Greece. On November 3, 2021, Judge Harris, in his white nationalism defense pleading, falsely states, because Spanos has never been served with the outstanding indictments. Moreover, Judge Harris is not an attorney, and thus he is not subject to discipline under the Virginia State Bar Rules of Professional Conduct. How can Lee Harris be a judge if he states he is not an attorney? All Virginia judges must be a licensed attorney in good standings with the Virginia State Bar for a minimum of 5 years. Judge Harris was fully aware that I had been served the 13 indictments in capias in accordance with the USA and Greece extradition treaty of 1932. Judge Harris recognized that the U.S. Supremacy Clause of the United States Constitution states that treaties are the supreme law of the land and the judges in every state shall be bound thereby. Judge Harris recognized and allowed Deputy Commonwealth Attorney Feimel to tamper with my court filings, remove my filings, remove exhibits of evidence, and even filing motions on my behalf before the original wet copy reached the Henrico County Circuit Court. Judge Harris and Deputy Commonwealth Attorney Feimel have had a total of 14 ex parte meetings to have my motions denied before the original wet copy had been filed with the Henrico clerk. Judge Harris recognized that my September 15, 2018 motion to dismiss was never filed until 20 months later, yet issued 14 orders for motions based on the September 25, 2018 motion to dismiss that was never in his files or in the Henrico clerk's office. On July 22, 2020, when Judge Harris and Deputy Commonwealth Attorney Feimel realized that the motion to dismiss had been removed from the Henrico clerk files, Deputy Commonwealth Attorney Feimel filed, without my knowledge, consent, or permission, my September 25, 2018 motion to dismiss without the exhibits of evidence. On July 24, 2020, Judge Harris signed the July 16, 2020 order denying my motion to dismiss, knowing that he had never seen or reviewed my motion to dismiss, even stating in his order that the motion was filed on July 22, 2020, 6 days after the hearing, giving more evidence that Judge Harris was making prearranged decisions with my filings. On December 10, 2021, Judge Harris falsely stated to the Joint Judicial Subcommittee that Mr. Spanos has never appeared before this court, yet his order states that I appeared before the court by video conference. A February 11, 2021 email by the Henrico Deputy Clerk stated that the Commonwealth Attorney was tampering with my motion to dismiss, removing exhibits of evidence, and filing the motion to dismiss on my behalf after the July 16, 2020 hearing. The Commonwealth's main witness, Sierra E. Cook, had a history of making false statements to Judge Harris in a previous custody case before him. Judge Harris recognized evidence that the main witness had a documented history of serious psychological problems and was taking prescribed medicines. Witness Sierra E. Cook had attempted to commit suicide prior to the grand jury hearings and was involuntarily held for 72 hours suicide watch at St. Mary's Hospital psychiatric ward. Yet the Commonwealth Attorney withheld the exculpatory evidence from the 3 accused men of color, which would have negated their guilt. Judge Harris recognized that the main witness, Sierra Cook, had a history of making several false reports to Henrico police, which were withdrawn or dismissed. Judge Harris recognized that the main witness, Sierra Cook, confessed to law enforcement authorities and the grand jury that she purchased large amounts of cocaine in New York and transported it to Virginia with intent to distribute. Judge Harris recognized that Sierra Cook never testified in court and was never charged or prosecuted for a role in the 600-kilo cocaine organization, as to protect the white affluent professionals from being charged and prosecuted and their names revealed in court. Judge Harris and numerous Henrico County Commonwealth attorneys recognized exculpatory evidence existed that would have negated the guilt of 3 accused men of color, and yet they withheld exculpatory evidence from them despite knowing this. Judge Harris sentenced these 3 men to prison. One was sentenced to 30 years. Judge Harris recognized that some 40 white affluent professionals had confessed to law enforcement authorities that they were part of a 600-kilo cocaine operation and violated Section 18.248, a Class 5 felony possession with intent to distribute a Schedule II substance, cocaine, which for the first offense conviction, the penalty is between 5 and 40 years in prison. Yet Judge Harris stood silent as Henrico prosecutors gave passes to the 40 white professionals, yet they prosecuted 3 men of color for the exact same crimes. Judge Harris placed the same exact felonies of 40 white affluent professionals on the backs of 3 men of color. Simply put, in Henrico County Circuit Court, Prosecution of the exact same felony depends on your skin color, ethnic race, or social status. Judge Harris has been protecting, promoting, and supporting a white nationalism doctrine for over 23 years in the Henrico County Circuit Court. Judge Harris and 8 other high-profile defendants listed in the October 6, 2021 ethics complaint have protected 40 white affluent professionals consisting of lawyers, doctors, and businessmen from prosecution despite their confessions to buying and selling large amounts of cocaine. There is no statute of limitation for narcotics violations. These 9 defendants continue to violate state and federal laws and the Constitution as to protect the white affluent professionals from being exposed at trial. The only way to protect these white affluent professionals is to make sure that I am kept in exile and never brought to trial in Henrico County for the 13 indictments for distribution of cocaine. Judge Harris refuses to follow the rules of court or the U.S. Constitution in my case. Judge Harris operates his court as a dictator, issuing orders as he pleases, knowing he is not following the rules of law or the Constitution. This is white nationalism, the belief, theory, or doctrine that white people are inherently superior to people from all other racial and ethnic groups, and they need or deserve preferential treatment and special legal protections. The obligation is yours to end racism in the Virginia justice system by denying the reappointment of Judge Harris, showing that white nationalism is not tolerated in the Virginia justice system. Thank you.